Hi friends, in this video we are going to deal with the case synopsis of the important and latest Supreme Court judgments pronounced now in the area of educational, land and tenancy laws. To know more about them, please watch the video fully. In the important judgment titled Central Council for Indian Medicine versus Karnataka Ayurveda Medical College and others, pronounced on 11th April 2022, the Supreme Court has held that the permission granted for undertaking admission of students for a subsequent academic year cannot be deemed to be permission granted for earlier academic year when the Ayurveda Medical College was not fulfilling the criteria of minimum standard as per the Indian Medicine Central Council Postgraduate Ayurveda Education Regulations 2016. The facts of the case would be that the Karnataka Ayurveda Medical College applied for permission to start PG course for the academic year 2014 and 15. The applicant granted permission to start 5 new PG Ayurvedic disciplines with 5 seats each in accordance with the then prevalent Indian Medicine Central Council Postgraduate Ayurveda Education Regulations 2012, which came to be superseded by the Indian Medicine Central Council Postgraduate Ayurveda Education Regulations 2016. The Karnataka Ayurveda Medical College collaborated with Sri Dharmasala Manjunadeshwara College of Ayurveda Udupi to use their animal house, which was permitted under the regulations. Before permission was granted for the academic year 2018 and 19, the Union of India directed Central Council for Indian Medicine to conduct an inspection and submit its recommendation. Relying upon the report of Central Council for the Indian Medicine, the Union of India issued a notice pointing out deficiencies. After hearing Karnataka Ayurveda Medical College, it rejected permission to admit students into the PG course for the academic year 2018 and 19. The Karnataka Ayurveda Medical College filed a writ petition before the High Court of Karnataka. In the meanwhile, the Union of India granted permission to admit students to its PG course for academic year 2019 and 20. The writ petition was allowed. The appeal by the present appellant before the division bench was dismissed. Hence, present appeal has been filed. The Supreme Court has held that the Indian Medicine Central Council Act 1970 was enacted in a backdrop wherein there was no central legislation to regulate the practice of Indian medicine and homeopathy. The Act was amended in 2003. Section 13A of the Act, inserted by the amendment, stated that medical colleges cannot be established without the permission of the central government. Therefore, any college desirous of seeking permission or to submit a scheme to the central government. Section 13(5) confers the power on the central government to disapprove the scheme after following the principles of natural justice. Section 22 would show that the Central Council is entitled to prescribe minimum standards of education in Indian medicine. Under Section 36, the Central Council is empowered to make regulations with previous sanction of the central government. Section 13A, read with Section 22 and 36 1J of the Act, provides a complete scheme for establishment of medical college, opening a new or higher course of study or training, including a postgraduate course of studying or training, and also increasing the admission capacity. Further, Regulation 3(1)A of the 2016 regulations provides that Ayurvedic colleges established in terms of the Act ought to fulfill requirements of basic standard for infrastructure and teaching and training facilities before 31st December of every year for consideration of grant of permissions for undertaking admissions in the coming academic session. The finding that the permission granted for a subsequent academic year would also inure to the benefit of earlier academic year, though the said institution was not fulfilling the criteria of minimum standard, is totally erroneous. The High Court had not considered the scheme of Section 13A of the Act while passing the impugned judgment. Though the judgment in the case of Ayurveda, Shastra Seva Mandal and another versus Union of India and others, reported in 2013-16 SCC 696, was specifically relied on by the appellant, the single judge and the division bench chose to rely on the earlier judgments of the division bench of the same High Court rather than a judgment of this court. Therefore, the single judge as well as the division bench grossly erred in not taking into consideration the scheme of the Act, so also the judgment of this court in the case of Ayurveda Shastra Seva Mandal. The common judgment and order delivered by the division bench and the judgment and order passed by the single judge are quashed and set aside. Coming to the next important judgment titled SUKH, RATRA and another versus State of Himachal Pradesh and others, pronounced on 6th April 2022. In this judgment, the Supreme Court has held that forcible dispossession of private property of a person without following due process of law is violative of both their human and constitutional rights. The facts of the case would be that the appellants claim to be owners of subject land. The state utilized the subject land and adjoining lands for construction of the Narak-Phagla road, but allegedly no land acquisition proceedings were initiated, nor compensation given to the appellants or owners of the adjoining land. The appellants filed a writ petition before the High Court of Himachal Pradesh seeking compensation for the subject land or initiation of acquisition proceedings under the Act. The High Court disposed of the writ petition with liberty to file a civil suit in accordance with the law. Being aggrieved, the appellants filed the present appeals with allegation that the state illegally usurped the appellants' lands without following due process of law. The Supreme Court has held that while the right to property is no longer a fundamental right, this right was still included in Part 3 of the Constitution at the time of dispossession of the subject land. The right against deprivation of property, unless in accordance with procedure established by law, continues to be a constitutional right under Article 300A. It is the cardinal principle of the rule of law that nobody can be deprived of liberty or property without due process or authorization of law. The facts of the present case would reveal that the state, in a clandestine and arbitrary manner, actively tried to limit dispersal of compensation as required by law only to those for which it was specifically provided by the courts rather than to all those who are entitled. This arbitrary action, which is also violative of the appellant's prevailing Article 31 right at the time of cause of action, warranted consideration and intervention by the High Court under its Article 226 jurisdiction. The contentions raised by the state do not inspire confidence and deserve to be rejected. The state merely averred to the appellant's alleged verbal consent or the lack of objection, but has not placed any material on record to substantiate this plea. Further, the state was unable to produce any evidence indicating that the land of the appellants was acquired in the manner known to law or that they ever paid any compensation. Further, in the absence of written consent to voluntarily give up their land, the appellants were entitled to compensation in terms of law. Thus, the forcible dispossession of a person of their private property without following due process of law was violative of both their human right and constitutional right under Article 300A. In view of this court's extraordinary jurisdiction under Article 136 and 142 of the Constitution, the state is hereby directed to treat the subject lands as a deemed acquisition and appropriately disperse compensation to the appellants in the same terms as the order of the reference court in land reference petition. The state is directed consequently to ensure that the appropriate land acquisition collector computes the compensation and disperses it to the appellants within 4 months from today. The appellants would also be entitled to consequential benefits of solatium and interest on all sums payable under law from the date of issuance of notification under Section 4 of the Act till the date of the impugned judgment. Therefore, the impugned order of the High Court is hereby set aside. Now we are going to deal with the important judgment titled ABID-UL-ISLAM versus S. INDER pronounced on 7th April 2022. In this judgment, the Supreme Court has held that a leave to defend under Section 25B of Delhi Rent Control Act 1958 cannot be granted on mere asking, and a tenant has to put in some material of substance to the extent of raising a triable issue. The facts of the case would be that the appellant, who claimed through the award and inheritance by operation of law, filed the eviction petition under Section 14(1)(e) read with Section 25(b) of the Delhi Rent Control Act. The tenant filed an application seeking leave to defend, raising some contentions. Rent controller dismissed the application. Allowing the revision petition filed by the tenant, the Delhi High Court observed that there are triable issues. Assigning the impugned decision rendered by the High Court, the present appeal is before this court. The Supreme Court has held that Section 14(1)(e) carves out an exception to the regular mode of eviction. Thus, in a case where a landlord makes an application seeking possession of the tenanted premises for his bona fide requirement, the rent controller may dispense with the protection prescribed under the Act and then grant an order of eviction. Requirement is the existence of bona fide need when there is no other reasonably suitable accommodation. Therefore, there has to be satisfaction on two grounds, namely the requirement being bona fide and the non-availability of a reasonably suitable residential accommodation. Such reasonableness along with suitability is to be seen from the perspective of the landlord and not the tenant. When the rent controller comes to the conclusion that there exists a bona fide need coupled with the satisfaction that there is no reasonably suitable residential accommodation, the twin conditions mandated under Section 14(1)(e) stand satisfied. For availing the leave to defend as envisaged under Section 25B(5), a mere assertion per se would not suffice, as Section 14(1)(e) creates a presumption subject to the satisfaction of the rent controller qua bona fide need in favor of the landlord, which is rebutable with some material of substance to the extent of raising a triable issue. The satisfaction of the rent controller in deciding on an application seeking leave to defend is obviously subjective. The degree of the probability is one of the preponderance forming the subjective satisfaction of the rent controller. Thus, the quality of the adjudication is between a mere moonshine and adequate material and evidence meant for the rejection of a normal application for eviction. Before a presumption is drawn, the landlord is duty bound to place prima facie material supported by the adequate averments. It is only thereafter the presumption gets attracted and the onus shifts on the tenant. The object of Section 14(1)(e) vis-a-vis Section 25B has to be seen in the light of yet another provision contained under Section 19, which gives the right to the dispossessed tenant for repossession if there is a non-compliance on the part of the landlord, albeit after eviction, to put the premises to use for the intended purpose. Such a right is available only to a tenant who stood dispossessed on the application filed by the landlord, invoking Section 14(1)(e) being allowed. Thus, Section 19 inter alia throws more light on the legislative objective, facilitating a speedy possession. The object is also reflected in the proviso to Section 25B(8) denying a right of appeal. The High Court is not expected to substitute and supplement its views with that of the trial court by exercising the appellate jurisdiction. Its role is to satisfy itself on the process adopted. The scope of interference by the High Court is very restrictive, and except in cases where there is an error apparent on the face of the record, which would only mean that in the absence of any adjudication per se, the High Court should not venture to disturb such a decision. There is no need for holding a roving inquiry in such matters, which would otherwise amount to converting the power of superintendence into that of a regular forced appeal, an act totally forbidden by the legislature. The rent controller passed a detailed speaking order. Having found that the defense set up by the respondent is only a moonshine, the application filed seeking leave to defend was accordingly rejected. The High Court, while ignoring the contact of the respondent as noted by the rent controller, proceeded to allow the revision by treating it like an appeal. It did not even reverse the findings of the rent controller, but proceeded to hold that the denials of the appellant in his reply to the application seeking leave to defend are vague qua the plea of the alternative accommodation, notwithstanding the rejection of the contention of the respondent that he cannot question the title. This approach cannot be sustained in the eye of the law. Therefore, the very basis upon which the revision was allowed is obviously wrong, being contrary to the very provision contained in section 14(1)(e) and section 25(b)(8). Further, the mere existence of the other properties which are in fact denied by the appellant would not inure to the benefit of the respondent. In the absence of any pleadings and supporting material before the rent controller to the effect that they are reasonably suitable for accommodation. Thus, the order of the High Court is set aside by restoring the order passed by the rent controller.